let Chris take it over. We're really grateful to have Chris Ball here with the Higher Ed Licensures Pros to really kind of dive into a deeper conversation on professional licensure compliance with a focus on the Illinois community colleges. Um, Pass it over to you to Chris to take it off whenever you're ready.
Great. Thanks so much, Jonathan. Thank you, everyone, for making time this afternoon to join me. I did put a link to my Google Drive in the chat where you can download your own copy of the slides I'm going to be sharing today. I think that these may be made available through MEC or someone else later afterwards as well, but I know sometimes folks like to have those available in real time for your own download or use. So you can do that through the Google Drive link that I just put in the chat if you wish. And I believe you can all see my screen that I'm sharing with the slides. So I'm going to go ahead and get us started here. Again, thanks for making time to join me today. My name is Chris Mall, and I am part of the team at Higher Education Licensure Pros. I've been doing this work in professional and occupational licensure compliance for over 15 years now. I kind of fell into this work after law school, worked for a large online university called Capella University located in Minnesota. I got to build and lead a team of professionals that was exclusively focused on professional and occupational licensure compliance issues. I know that most institutions do not have the luxury to have a team dedicated to this work, let alone one full-time person even. So that's why I, along with my colleague and co-founder Nan Kalki, created Higher Education Licensure Pros a few years ago to help support institutions with this important compliance work. So that's a little bit about me. What are we going to do together for the next about hour that we have left today? Here's what I have in mind. So first, I'm going to do an overview of what's required under the current Title IV federal financial aid regulations, as well as SARA policy related to professional and occupational licensure compliance. So I'll give that high level overview to start with. And then I want to spend some time diving into some of the specific challenges and considerations when you're working through implementing these regulations and policy at your institution. So I have a few areas that I've pulled out that I'm going to focus on today. You can see those here on the agenda. But I do welcome your questions about anything related to this topic. Feel free to put those in the chat as I'm going along throughout the presentation. I will have some time left at the end to get to those. So again, feel free to put those in the chat, or when we have time at the end, if you'd like to ask your question live, you can of course come off of mute or come on camera to do that as well. So one quick note there, you'll see at the bottom of the slide, while I am an attorney, I am not your attorney. I'm not any institution's attorney. So what I'm going to be sharing today should not be taken as legal advice. And like many compliance topics, it is important to get your own legal counsel on some of these things before you're making decisions and implementing processes and policies in support of these regulations. All right, I'm going to jump right in then to that high level overview. So when we talk about professional and occupational licensure compliance, the way that I like to break it down is there are really three main responsibilities that all institutions have if you participate in the Title IV program, which is federal financial aid, or if you participate in SARA, the State Authorization Reciprocity Agreement. So these three responsibilities at a high level are understanding how your licensure programs meet the educational requirements for licensure in US states and territories. Next responsibility is you need to certify that your licensure programs do meet the educational requirements where you're enrolling students and where you're advertising and recruiting for your licensure programs. And the third responsibility is around communicating. So institutions have a responsibility to communicate certain information at different times to different audiences when it comes to professional and occupational licensure information. So I'm going to dig into each of these three responsibilities in a little more detail here on the next few slides. So that first one again is understanding. Institutions must understand how your licensure programs meet educational requirements in every US state and territory where you're recruiting students, advertising these programs, and most importantly, where you're enrolling students. So let's break this down a little bit more. What do we mean by licensure? Licensure is really an umbrella term in this case, and it can be called something else depending on the state that you're talking about or the particular occupation or profession. But essentially, licensure is any type of credential that's required for employment that is issued by a state or territory government entity. So these are not like nice to have credentials or nice to have certifications. This would be something that is required in order for one of your graduates to be eligible to work in that occupation or profession in that particular state or territory. So licensure, again, it could be called something completely different: registration, authorization, certification, endorsement. Licensure is that umbrella term. So I'm going to keep saying that today. And the Department of Education and Sarah also use licensure as the term, but it could be something different than that when you actually start digging into the details. So, what's a licensure program then? Well, unfortunately, we do not have a list provided by the US Department of Education or anyone else that gives us a comprehensive, picture of all of the licensure programs that could exist for your institution or for all institutions. It is up to each institution to determine which of your programs are licensure programs. So, how do you go about doing that? Well, the main ways that you should be thinking about this are: how have your programs been designed? Are they aligned with a particular occupation or profession that requires a license in order to work? If that's true, then yes, it's likely a licensure program. And how has it been, or how is it being advertised or marketed? So, if you have information on your website or in your catalog where you're describing the program in a way that it makes it seem like someone could achieve a license, or that it's helping prepare someone for an occupation or career that requires a license, then it's likely a licensure program. So those two criteria again are really: what's it designed for and what's it being advertised to do. So if either one of those things is related to license or an occupation or profession that requires a license in some way, then you're likely talking about a licensure program. And it should be on your list here for these compliance purposes. I think I did neglect to say that this understanding requirement applies to all of your programs, no matter the modality of delivery. Sometimes I hear from institutions a misunderstanding that this is only for distance education programs or online programs. That is not true. These Title IV regulations and the related SARA policy apply equally across all modalities of delivery. So whether you're talking about a purely on campus, face to face program, or a fully online or some hybrid. These regulations and requirements apply equally. There are some specifics when we talk about distance education students, and there's a unique definition for distance education here that I'll get to in a moment. But in general, again, these do apply to all of your licensure programs, no matter how they're being delivered. And the final thing I want to say about understanding is really, how do you do that? How do you come to an understanding about your licensure programs? Well, in order to do that, you must dig in and research what each state and territory requires as far as those unique educational requirements. So, because licensure is something governed at the state level, there is not a national, true national standard that applies to any one occupation or profession. We will see that a number of occupations and professions align behind national examination, for example, or some sort of specialized accreditor that would apply equally across, the whole country. But there can still be nuances and specific requirements that are at play for some states or territories. So it is important to dig in and do that research to understand and know what each state and territory is going to be requiring of your graduates when they actually go to apply for a license. And then institutions need to compare their programs to what those specific educational requirements are. Once you've done that comparison, then you can have that understanding if your program does in fact meet the educational requirements or not. All right, the second responsibility then is around certifying. This is a new responsibility that just came online this July 1st, and it's related to the Program Participation Agreement, the PPA, which is essentially the master contract that every institution has to sign with the US Department of Education in order to participate in the Title IV federal financial aid program. So, in order for your students to be eligible and be able to access student loans, you must agree to everything in the PPA, all those terms and conditions. And this new term, this latest term, is related to professional and occupational licensure. So now every institution must certify that your programs do meet the educational requirements where your institution is located. So, Illinois, for all of you, that's probably the easiest part of all this. And you have to be able to certify that your programs meet the educational requirements where your distance education students are located at the time of initial enrollment. So, the tricky part here is the definition of distance education that the US Department of Ed is using. So you'll see on this slide here, Department of Ed is applying a very broad definition for distance education. If a student will be taking one or more class online during that first term of enrollment in the licensure program, they're considered a distance education student under this subsection of the regulation. So what that means is, you could have somebody coming into one of your licensure programs that's going to take a gen ed course during that first semester of enrollment. They're considered a distance education student. So wherever they are located at the time of initial enrollment in the licensure program, you would have to be able to certify that your program does meet the educational requirements where they're located. If you can't certify, you could still enroll that prospective student or student as long as they go through an exception process, the written attestation process. Again, this is brand new as of July 1st. Basically, what it requires is that institutions procure written documentation from a prospective student if they're located somewhere where your program does not meet the educational requirements or where you haven't determined if it meets it. And the student has to attest in writing to a couple of specific things, primarily that they actually intend to seek licensure and employment in a state or territory where your program does meet the educational requirements. So this could be in Illinois, or it could be in any other state where you've determined that your program does meet the educational requirements. So if they put that in writing and you secure that as part of a written attestation process, where you're helping educate and inform the student about licensure and what the limitations of your program are and what this written attestation is. And then ultimately you secure that written documentation, you could still enroll that student. So just to make it crystal clear here at the bottom of the slide, institutions cannot enroll students unless they're located in a meets state or territory, or if you secure this written attestation from them. Again, this is all new as of this July 1st. So the third responsibility is around communicating, and there are two buckets to this communicating responsibility. One is around what do you need to communicate publicly, and the second is around what do you need to communicate directly to your students or prospective students. And the public piece is known as public disclosures. This is typically done through an institution's website. And under the new July 1 version of the Title IV regulations, institutions must disclose those states and territories where you've determined that your program meets the educational requirements and those where you've determined it does not meet. So some of you, if you've been doing this work for a number of years, you'll recall that was this third category of not determined or no determination made. Honestly, a lot of institutions had a pretty large number of states and territories listed in that third category on their public disclosures, where you hadn't determined if it meets or doesn't meet. That not determined category is no longer required under the July 1 version of these regulations. However, institutions could still choose to list those states and territories where you've not determined, as that's applicable. So there's nothing preventing you from doing that. It's just no longer required under the current version of the Title IV regulations. If institutions are disclosing not determined states and territories still on your public disclosures, I do just want to point out a connection to SARA policy here, where there's a little difference between the Title IV regulation and the policy requirement under SARA. So if you're disclosing not determined, you should be including contact information for that state or territory licensing board or agency and directing people to connect with that licensing board themselves to try to make a determination. So again, that is part of the SARA policy. It's not part of the Title IV regulation. It is something to keep in mind if you are disclosing publicly some not determined states or territories. That second, again, part of communicating is around individual direct disclosures. These are typically done through email, although technically can be in any written format to your prospective students and students. These are going to be tied directly to the student's location. And student's location is determined by each institution's own student location policy. We're going to get into the weeds a little bit more on student location policy here in a few minutes. But just know that there is not one prescribed location policy that the US Department of Education has dictated here. It is up to each institution to have your own student location policy in place that you are using for these purposes to determine where your prospective students and students are located. So, if your student location policy is indicating that a prospective student or applicant is located in a not determined or a does not meet state or territory, then you do need to send them a written direct disclosure that lets them know that, hey, you're located in a state where our program does not meet the educational requirements. As a side note, these are the same prospective students or applicants that will now have to go through that written attestation exception process in order for the institution to actually enroll the student. Because again, you cannot enroll a student unless they're located in a meet state or territory or you secure that written attestation. So, in addition to the prior to initial enrollment disclosures, you do have a responsibility for your current students to send direct disclosures sometimes, depending on the circumstances. So, if that current student changes locations and now they're in a does not meet state or territory, you would need to send them a direct disclosure within 14 calendar days of becoming aware of their location change. If something changes with a state's requirements and now your program no longer meets those educational requirements, you would need to notify all of your students located in that state within 14 calendar days of becoming aware of that change. So just keep that in mind. And the 14 calendar days, again, is directly from the regulation. That's the responsibility and expectation that the Department of Ed has put on institutions. Really quickly, I just wanted to point this out in case you hadn't heard of it, or maybe someone else at your institution knows about it, but you weren't familiar with it. As part of this particular subsection of the regulation, Department of Education did put out an electronic announcement where basically they provided a small window of opportunity for some institutions to document that they were going to be out of compliance starting July 1. And there were things that that institution um, were steps they were going to be taking to get into compliance. So essentially, if you weren't fully compliant by July 1st, maybe yourself or someone at your institution were documenting those reasons why you weren't in compliance. If it was totally outside of your institution's control, things that were time limited circumstances, and you're able to document that, the Department of Education has said that could be used as a defense to any enforcement action that may come up in the next 6 months. So, um, probably doesn't apply to most of you, but it may to some. So, I just wanted to mention it. Just a note though, this is not a delay of the effective date of these regulations for anyone. Again, the expectation is everyone is compliant or working towards compliance, but there may be some of these unique circumstances for some institutions that you've documented. And it only impacts the new certify responsibility. It does not apply to the disclosures. So also keep that in mind that that's really specific to the certify responsibility under the PPA certification. All right, last slide here, just again, kind of bigger picture, right? Why are you spending your time on this today? Why am I talking about this again? Um, this is important, right? This is a Title IV regulation. And so any sort of enforcement action, any sort of non-compliance finding that would happen ultimately could result in the same types of measures and penalties of any Title IV issue. So because it's part of that, it is important to each institution's eligibility to continue participating in the Title IV program and having your students be able to access those student loans and other Title IV funds. So really important stuff here. There's some other related things at play as well. So maybe some of you have been hearing about, borrower defense to repayment claims. Over the past couple of years in particular, there has been a significant increase in these coming through, and the way that the department is really pushing them through pretty quickly to many institutions. And so licensure has come up in some of these borrower defense to repayment claims, which essentially, our students or graduates' ability to point out issues that they had as part of their experience in institutions and say, hey, I shouldn't be responsible for repaying my loans because of X, Y, and Z. And again, licensure related issues have come up in some of these claims. So important to make sure that your institution is meeting these three responsibilities and doing what you can here to help minimize those borrower defense claims as well. In addition to the SARA policy I mentioned, pointed out, obviously those of you who have been doing this work, and especially if you also do your SARA work for your institution, know that there are often questions on your SARA renewal applications or documentation that you need to send to your state portal entity in order to have approval under SARA that's related to this work, to the licensure disclosures and other licensure responsibilities. So another important consideration here for your ability to offer programs, especially offer programs outside of Illinois. So a few challenges, and we're going to get into more of these challenges here in a moment in more detail. But um, one big challenge is because every state and territory gets to set their own educational requirements for licensure, you know, again, we're going to see inconsistencies across states for these various occupations and professions. And generally, state licensing boards and agencies do not review or offer any sort of approvals for out of state programs. So you may be familiar for your Illinois boards or agencies. Nursing is an example, right? You submit your curriculum to your nursing board, they review it, and then they grant an approval from that board or IFDPR in Illinois' case in order to offer that nursing program. But that mechanism doesn't exist for out of state institutions or out of state programs for the most part. So, really, it's up to you at your institution and your curriculum experts to make that judgment call if your curriculum meets the educational requirements or not. So, it's definitely a challenge and it takes a considerable amount of time and work. And we're going to get into that here in a moment with some more challenges. So with that, I am going to shift gears here into some specific challenges and considerations for implementing these regulations. And if you all would be so kind, I have a few poll questions here that I've integrated into some of these slides. So here's the first one. If you haven't used Slido before, it's just a poll feature. You can go to slido.com from your browser, and then you type in the numbers there, 2743625. It'll take you to the first poll question. Or if you want to use your phone or other mobile device, you can scan the QR code that you see here on the slide. It's going to take you directly to the poll question for this one. So I'll give you all a moment here. I'm going to go ahead and present this so that we can see the results as they're coming in. So the first question, which of the following are licensure programs? So I've got a number of programs listed here. You can select more than one option, and we've got some answers coming in here. You can see the results live on the screen. So I'll just wait another 30 seconds or so and let more of you put your answers in. some of these programs probably look familiar. Your institution's offering maybe one or more of these. Um, Pretty typical or common licensure related programs potentially at some institutions. So all right, I'm going to move on. Thanks for all of you who are able to answer for chiming in here. It looks like the winner is all of the above could be licensure programs. And I would say um, that's my best answer as well. So um, let's go ahead and talk about that a little bit, right? Why could they all be licensure programs potentially? So again, I'm going to harken back to what I said a few minutes ago. It's really about what the program's been designed to do and what it's being advertised to do, right? So we don't have that key master list from US Department of Education or anyone else. So it is up to each institution to determine which of your programs are licensure programs or not. So when you're thinking about that designed piece, right, you can look at things like how has the curriculum been designed? What has it been aligned to? What kind of particular standards? This may include programmatic or specialized accreditors or some sort of national standards that are being used around the curriculum. Is there some connection to an occupational or professional license as part of that specialized accreditor or those standards, right? That's a pretty good clue that yes, it's a licensure program if that connection exists. Also, is there some sort of licensing exam that is expected of your students or graduates to take? And if so, is that being reported to anyone? If there's a yes to either of those, then that's a pretty good indication that this is a licensure program that we're talking about here. And then, maybe this seems pretty on the surface here, but is it expected that most of your graduates will seek a license, right? So if you talk to that program director or faculty within the program, would they expect that most of your students or graduates are actually going to seek a license after they graduate? If the answer is yes, then probably that program belongs on your list of licensure programs. Some things with the advertising to keep in mind is really, take a close look at the program description. So as I was mentioning before, right, it may not be as specific as this program is designed to prepare you for a license in this occupation. It could be something where the program is being described in a way to help prepare students for an occupation that does require a license. So even if the word licensure or license or certification or whatever that term is, even if it doesn't come up in the program description language itself, you could still have a licensure program here, depending on how that program's being described and talked about, what those career outcomes are, what that occupation is that it's related to. All right, I'm going to keep going here. Next couple slides, I kind of have in a Q&A format. So we've been presenting to a lot of different institutions over the past 6+ months on these July 1st changes. So we have been getting a fair amount of questions, and some of them are keep coming up frequently. So I've got a few of those on the next couple slides here. But with the research and curriculum comparison piece, that understanding component, how do you know when you need to do really in-depth comparison of your program? And is it something that I just need to do once, or how often am I going to need to do this? So to answer the first part of the question, generally, when you start doing the research into what each state and territory requires, it's going to become clear pretty quickly that an in-depth or a detailed curriculum comparison will be needed. So just as an example, right, you could have a state where they say, bring us a program that holds this specialized accreditation and it meets our educational requirements. That'll be clear in the law itself, in the statute or regulation, and probably also on the board's website. Those are the easier, I should say, states that would not require a very detailed comparison to your curriculum. Assuming that you hold that specialized accreditation, then you can say, yes, our program meets the educational requirements. On the other hand, you could have states where they have very specific number of credits that are required in different coursework or subject areas, or specific number of training hours. So in those instances, if you need to, be able to document that your program has 100 training hours of this particular content or subject, someone will need to dig into your program's curriculum and ensure that you have that specific number of clock hours or credits or whatever it is before you can say that your program meets the educational requirements. So again, that typically will be pretty clear once you start looking at the state statutes or regulations themselves or the materials available on the board's website. If they're looking for a specific number of credits or training hours or clock hours, or if they're looking for something else, like that the program holds a specialized or programmatic accreditation. Oh, and by the way, it's not a one and done thing. So, like most compliance work, this will be an ongoing effort, in particular for those states that require the more detailed comparison to your curriculum, to your classes, to your training hours. You will need to set up a process where that's being regularly reviewed because the state can change its requirements from time to time. And obviously, your program can change its curriculum as well. So you do need to make sure there's a regular review happening for those program comparisons. And this work can take a considerable amount of time and people power. So as I was mentioning, right, the primary source for this information is in state law. So in state statutes, regulations, rules, licensing board and agency policy manuals, that's where this detail is going to live. What are the educational requirements? What type of program or certificate degree is required? Are there specific classes? How many credits? How many clock hours? Is there a practicum or some sort of clinical experience required in the program? All of that will be detailed in the law itself typically. Um, what else to say about that? I do want to point out specifically documenting these determinations. So even if it's a case where you find that a state will accept a specialized accreditation as meeting all the educational requirements, you will want to document that and retain the documentation somewhere. So in the event that your institution is ever audited by Department of Ed or someone else, you'll be able to point back and say, well, in September 2024, we did the research. This state was requiring this specialized accreditation for the program, and we had that accreditation at the time. That's how we know that our program meets it. So, having some sort of spreadsheet or other written documentation where you really are listing out state by state what's required for educational requirements and how your program is satisfying that will be a key piece of evidence should you ever need to produce that for an audit in the future. I'm going to move on then to the next kind of implementation consideration. So Department of Education in the July 1st regulations introduced kind of this new to them, it's not a new idea, but new to them, that institutions can factor in licensure compacts and reciprocity agreements when you're making these determinations about your programs, if they meet or don't meet the educational requirements. So what does this mean, right? Can you rely on the fact that there's a licensing compact that exists? Well, maybe. So, licensing compacts broadly are agreements that are made between states to help facilitate the movement of licensed professionals or the working of licensed professionals across state lines. And they do that in a number of different ways. So, it can really truly be about the ability to practice across the state line. If you think about, some of our healthcare related professions and the rise of telehealth, right? You often have people who never are physically even going to another state. They're just providing services virtually now. And they're able to do that quite often because of licensing compacts that are providing them that ability to practice across state lines, through that telehealth portal or system, whatever that is. Other agreements are set up differently, compacts or reciprocity agreements, where they're really a way for someone to be able to achieve a license in another state more easily or with less hurdles. And so it's these types of compacts and reciprocity agreements that are really the most useful when you're taking a look at, can our graduates use these types of agreements or compacts to satisfy the educational requirements. So the Department of Education gave an example specific to a teacher, classroom teacher, when they were talking about this in their commentary. But essentially, the example was, somebody's able to achieve a temporary type license in the new state using their existing license that they earned by completing the program. There may be a deficiency in a very specific state class or something, but as long as that teacher can be teaching in the new state classroom and they have some sort of provisional or temporary license, then the Department of Education would be okay with an institution saying that you meet the educational requirements in those circumstances. So we can dig more into that one if people have questions. But the highlights are maybe you can use the existence of a compact or reciprocity agreement, but it's not something that I would say you should absolutely rely on blanket wholesale. It does depend on a number of these factors that you see on the slide here. Who's it actually covering? What's it actually going to allow your recent graduate to do? And can they achieve a license, or is it really just about that ability to practice across state lines, not earning a new license in the other state? So I have another poll question here. You'd be so happy, you'd be so inclined, I'd be happy for you to do that. If you can go to slido.com 4189360, or again, you can scan the QR code with your phone or other mobile device. It'll take you right to the poll question. And I'm going to go ahead and pull up this one here. Give everyone just a minute or so to put in your own answers if you want. So again, let me share this one. Here we go. This is about student location. So where is this prospective student located? They temporarily live in South Carolina while they're completing some military training, but their permanent address is in Wisconsin. They are applying to an online associate's program at your Illinois institution. So where is this particular prospective student located? I'll wait just another 30 seconds or so here.
Hmm.
All right, thanks for those of you answering. It looks like the winning response is it depends on the institution's student location policy. And then we've got a few coming in for South Carolina and a couple for Wisconsin. So thanks for that. Um, Yeah, it truly does depend on the institution's student location policy in this case. So, what do we need to think about when you're thinking about student location policies? Well, as I mentioned before, right, every institution needs to have a student location policy that's going to be used for the purposes of determining where your prospective students and students are located under these regulations. And this is both for the purposes of that PPA certification, the certified responsibility, as well as the direct disclosures that are under that communicate responsibility. So this policy should be like any other formal policy that your institution has, something that's reviewed and updated on a regular basis. It does need to be applied consistently at your institution and made available to the Department of Education if requested. Those are the parameters that the Department of Ed has applied. So they have not provided, as I mentioned before, specifics on what that policy needs to say or how it needs to treat particular students. The Department of Ed did indicate that institutions can factor in differences between different groups or populations of students. For example, not as applicable to you all, but graduate versus undergraduate students could be treated differently. If you have international students or military affiliated students, you can consider how they might be treated differently, or consider how they should be treated in your policy and spell that out specifically for those particular populations of students.
Yeah. Right.
Something else that may apply to some of you, again, depending on geography. It's important to keep in mind is if you have students commuting across state borders, so think about how your student location policy, when you apply that, is going to impact those commuting students that could be, residing in Wisconsin, for example, while they're going to be commuting to your campus most of the time to take their classes face to face. If they're going to be physically in Wisconsin when they're taking an online class during that first term of enrollment, they're a distance education student for the purposes of this particular subsection of the regulation, which, again, depending on how your student location policy is set up, you would then need to make sure that your program meets the educational requirements in Wisconsin, not just in Illinois. So again, we can talk through questions if people have them here in a few minutes. But when you get access to the slides, again, you can see that in the chat. I had a link you could download there, or you can get them later on from Mac. I think we'll be making them available. But there are some example student location policies and as well as written attestations that we provided there on a link. I have a couple on the slide here I just wanted to point out quickly. So again, every institution gets to craft your own student location policy, and it should make sense for your unique student population and the types of programs that you offer, and kind of how they're delivered broadly. So this particular institution set up their location policy in this way, that this is kind of the introductory why they're setting this up, that they need to do it to disclose state specific information at the time of enrollment, and then once a student notifies them of any changes, and that there are other college and system policies that determine residency for tuition purposes that are not part of this policy. Could be a factor for some of you when you're creating your own. But this is really the meat of it I wanted to point out here. So this particular one for prospective students, the prospective student's location is the state of the prospective student's residency at the time the student has applied for admission, intends to enroll, and is then entered into the student record system. So going back to the poll question, if that prospective student or applicant is located in South Carolina, if that's their residency, even if it's temporary, but if that's where they're at this point in time when they're intending to enroll in the program, then per this location policy, that student would be treated as if they're located in South Carolina. So this institution would have to be able to say that their program meets the educational requirements in South Carolina in order to enroll this student, or they would have to secure the written attestation where the student indicates that they actually want to seek licensure and employment in Illinois or some other state where the program's determined that they meet the educational requirements. As a second example here, taking a different tact, this institution's student location policy is set up in a way where they are indicating that the physical address where the student currently or will live or frequently stay during the time that they will be taking classes for the upcoming term is where their location is at for this prospective student or applicant. So if you go back to the poll question, right, if their permanent address was Wisconsin, they're applying for a program in Illinois, we don't really have enough information from the poll question to know where they're intending to actually live or frequently stay during that first term of enrollment, where they're going to be putting their head down at night, which is what the rest of this policy says. So we would need to know that information. If it's going to be in Wisconsin at that permanent address, then they would be treated as a Wisconsin located student. If they're going to instead be relocating to Illinois, right, then they would be treated as located in Illinois for these purposes. All right, I just have a few more slides and then I do want to have time for your questions here. So the written attestation, we talked about this in the summary a little bit, but just for some more detail here. So again, Department of Education has indicated that their expectation is this is more than just a written document, more than a form, more than a checkbox as part of an application process. Their expectation is that there is some sort of interaction between the institution and the prospective student or applicant before you get to the point of that written documentation itself for the written attestation. So, automated forms probably are not going to cut it, definitely not by themselves. There would need to be more of a process in place around that, again, to educate the student about what the limitations are of your licensure program, where it's not meeting the requirements, what the written attestation is, what it means if the student is signing that, and then ultimately securing that written attestation from the student for that one particular named meets state or territory. They have to indicate they intend to seek licensure and employment in one state or territory. It's not enough to say, I'm going to seek a license somewhere where I can get it, or list off 5 potential states. It does need to say one state or territory where the program meets the educational requirements. And then on this slide, some things to consider. Again, you'll have access to this afterwards, but as I've mentioned now a couple times, it's really more than just a document or documentation when we talk about written attestation. It's a process. So it is important that someone at the institution is having an interaction with that student at some point to understand what their intention is, that they do actually intend to seek licensure and employment in a meet state. And if that is all true, then this written attestation process can be the written attestation documentation can be secured from that prospective student at that point, which is what you would need to retain in that student's record and be able to make that available to Department of Education in the future for any audit purposes or other reasons should they ask. Because really, again, this is an exception. This is an ability for an institution to enroll a student who otherwise would not be eligible to enroll in your program. So having that documentation in place and retaining that and being able to make that available is a very important step in this process. All right, I have one more poll question, and then we'll have about 10 plus minutes left for questions here. So if you can go to slido.com one more time, do number 1174620, or go ahead and select that QR code that you see on the screen. And this poll is related to direct disclosures. So, is a direct disclosure required? Remember, direct disclosure is one of those two communicating responsibilities. And you need to send direct disclosures to prospective students before the time of initial enrollment in the program in a couple of scenarios if they're located somewhere where the program does not meet or you've not determined. So that is the high level requirement here. So is a direct disclosure required if a prospective student, that's what PS means, if a prospective student lives in Guam, they're applying to a certificate in court reporting program in Illinois, they plan to live with their family in Wisconsin while they're enrolled, this institution has not made a licensure determination about the program for Wisconsin or Guam. So, do we need to send this prospective student a direct disclosure? And if so, for which location? Do we need to send it for Guam? Do we need to send it for Wisconsin? Or is it going to depend on one of these factors here? I'll wait about another 20 seconds here, let maybe a few more responses come in. Thank you for everyone who's continuing to participate in the polls. I always enjoy seeing the responses. It looks like the winner, the most responses for this one is yes, we do need a direct disclosure. And Guam is winning out for the particular location. Some of you also said yes for Wisconsin. And then we've got a number of responses saying it depends on the institution student location policy. So, um, yeah, I mean, theoretically, all of you could be correct. So it does depend on the institution student location policy in this case, right? So if that particular student is considered located in Guam based on the institution student location policy, then certainly they would need a direct disclosure because the institution has not determined if it meets Guam's requirements. Similar for Wisconsin, right? The institution is not determined if it meets Wisconsin's requirements. So they would need to send that direct disclosure if the student's considered located in Wisconsin. So just as a reminder here, I talked about these before, but these are the disclosure considerations. So again, you have that public disclosure responsibility, listing those states and territories where your program meets and does not meet. You could still list not determined if you want to. It's no longer required under the Title IV regulation. Just know that Department of Ed staff have indicated you should only be advertising licensure programs and recruiting students in states where you know your program meets the educational requirements. So it's not just the enrolling piece, but the Department of Education staff is kind of extending that to advertising for that particular licensure program and recruiting students. So if you're recruiting or advertising in Guam, then you need to know that your program meets the educational requirements in Guam in order to be doing that for the department staff. And then direct disclosures, again, it's really all connected back to your student location policy. And if that prospective student is located and it does not meet or not determined, you need to send them that direct disclosure prior to initial enrollment. So I am going to shift over here to questions now. And as I do that, maybe quickly, I did want to just let folks know that Higher Education Licensure Pros works with colleges and universities across the country, including some in Illinois and including community and technical colleges across the country. So we do that in a number of different ways. We can provide consultation, helping you establish your student location policy, your written attestation process, those disclosures, all of that good stuff. We also created the Bookmark, which is an online database of educational requirements for licensure. We have close to 80 different license types available now, and we're continuing to build that out over time. And so what the Bookmark does is it saves the schools that work with us a considerable amount of time and effort having to go out and research and find what those educational requirements are across the various states and territories. Instead, they can come to the Bookmark where we've already done that research and compiled it into one source for those colleges and universities to use. So does anyone have any questions? Happy to take those in the chat. I don't see any in the chat right now. Also happy to take them if you wanted to come off of mute and ask.
Hello, Chris. Can you hear me?
Yes, go ahead.
I'm Ike Mosu. I'm VP at Lakeland College in Mattoon. And I had met with Nan, I think in June,
Sure.
over this. And I was wondering, I don't know if this is an ICCB question or you can help us here. Since we seem to be all on in the same boat regarding this, couldn't we approach your services from a state consortium-wide availability that we could all, subscribe to statewide as opposed to individual institutions?
Yeah, thanks for that question, Ike. So we do offer, we call it an enterprise level membership to the Bookmark, in particular, where we allow, colleges or institutions to come together as a group. So in this case, if it would make sense for your group of Illinois community colleges to come together and do an enterprise agreement, that's something that we'd be most willing to talk to you all about. We do have other groups of institutions at different levels, whether it's, a state public system of schools or private nonprofit institution organizations that have come together to do those kind of enterprise agreements. So it's nice because it can save the institution's cost, right? So we were able to reduce the cost per user seat to access the bookmark for that enterprise level. And we also are able to offer some additional benefits to our enterprise members, like webinars similar to this that we put on just for those enterprise members and additional resources.
Thank you. Is there a person should I just reach out to you and none about that possibility for community colleges?
Yeah, I think the biggest thing for on our end would be when we do an enterprise agreement, we do want to just have one entity that we're contracting with for the agreement, right? So whoever would be that person, like that, that contact, if we could get them involved too, that would be, I think, a great way to get the conversation started or to figure out next steps to make that happen.
Okay, thank you.
You're welcome. Thank you. I do see a question here in the chat from Dane. For public disclosures, can we focus on those states where we either advertise or serve students and then simply not report on other states, or else report not met or unknown, and to reduce our research burden? So the short answer, Dane, is yes, you are correct. So as long as you are not enrolling, advertising, or recruiting students in a particular state or territory, then you do not have an obligation to make a determination. So the Department of Education was very clear about that in their commentary that they released with the final regulations. They do not expect all institutions to be making determinations for all 59 US states and territories for all of your programs. They are concerned about where are you enrolling students from, where are you advertising that licensure program, and where are you recruiting. So if you're limiting those advertising and recruiting activities, and if you're not enrolling students located in a particular state or territory, then you don't have an obligation to make a determination one way or the other. And for your public disclosures, you can choose to just not include those states or territories on your public disclosure list at all. If you haven't made a determination, you don't have to list the not determined ones at this point. I know that many institutions are choosing to still do that just to avoid some confusion, right? So if your public disclosures would list Illinois, yes, Indiana, yes, Wisconsin, no, and then you have no other states listed, it might cause more questions than anything else. So, as I said, some institutions are still choosing to list all of the other states and territories where they've not determined, just to avoid some confusion potentially. We have a couple more minutes here. If anyone else has other questions, I'll just point out for the slides again, I have some more resource slides at the end. So if you want more information on these requirements, there's some additional resources you can find on the slides at the end of the presentation. And I've actually included the regulation language itself, as well as a link to the Code of Federal Register if you want to read that or take a more close look at that for yourselves. And then here I'll leave our contact information up here. You can find us at our website, higheredlicensurepros.com, and I'm always happy to talk to anyone about these licensure compliance issues. So feel free to reach out through email or phone, or you can find me on LinkedIn too in the future.
Well, thank you, Chris, so much for coming here today and sharing all this information. I know I continue to learn a lot as I have been doing this, but even every time I hear you talk, I learn a little bit more. So I really appreciate you taking the time, and I appreciate everybody else joining and learning and helping ensure that all of our institutions are responding in the best way possible to these constant changes. So thank you all for coming as well.
Thank you all. Have a good rest of your day.